Good morning, ladies and gentlemen. Welcome back to Bexar County Court of Law number 6 and the Bexar County Veterans Treatment Court. Today is Wednesday, the 4th of May, 2022. This is our Zoom motion to revoke probation docket. Representing the state in all matters will be Mr. Eddie Villarreal, Mr. Arthur Reed. Representing the Bexar County CSCD will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. The cases I have set for hearing today are cause 679-513, 683-606, and 683-607, State of Texas versus Edward Reyes, represented by Miss Mary Petracek. And Miss Petracek is not with us yet, is that correct?
That's correct.
Cause 650-961, State of Texas versus Francisco Tovar, represented by Mr. Leslie Herbst. Is Mr. Herbst with us? I do see Mr. Herbst. Mr. Herbst, are you ready to proceed, sir?
I would like to confer with the state.
Sure. In the future, please try to do that before the day of hearing. Cause 667-828, State of Texas versus Joe Garcia, represented by Mr. Ross Brandell. Mr. Brandell, are you ready to proceed?
Yes, Your Honor.
Thank you. And cause 645-927, State of Texas versus Melanie Lopez, represented by Mr. Robert Maurer. Is Mr. Maurer with us?
Not yet, Your Honor.
We'll wait on Mr. Maurer and Mr. Lopez. Okay. Let's proceed on Mr. Brendell's case, cause 667-828, State of Texas versus Joe Garcia. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which is purportedly signed by both Mr. Garcia and his attorney, Mr. Brendell. In fact, Mr. Garcia, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Brendell, as attorney for Mr. Garcia, is this also your signature on this document?
Yes, Your Honor.
Thank you. The next document I have on this case is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Once again, this is cause 667-828, State of Texas versus Joe Benjamin Garcia, and this is a motion to enter adjudication of guilt and revoke community supervision. On the trial court certification of defendant's right of appeal, is this your signature on this document also, Mr. Garcia?
Yes, sir.
And also, Mr. Brendell, as attorney for Mr. Garcia, is this your signature on this document?
Yes, Your Honor.
Thank you. Mr. Brendell, my understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
We are, it's partly, we're not saying that the allegations that he may have skipped some tests or late tests was false, but we are, there are some high BACs they said there was, but it was only like 0.01 or 0.02. And the calibration with these breathalyzers, there's a range of error between that amount.
All right, well, hang on, just let me hold you up there. Basically, we haven't gotten to that point yet.
Okay.
What I need to know at this time is there are two basic levels of motions to enter adjudication of guilt and revoke community supervision. And the first one is what I call a full-blown motion to enter adjudication of guilt and revoke community supervision, where the defendant enters a plea of not true and requests a full-blown motion to enter adjudication of guilt and revoke community supervision because it is contested. The second one is where he can enter whatever plea he wants to any of these conditions he wants, and you're not requesting a full-blown motion to enter adjudication of guilt, but you're obviously just going to me as a trier of fact to make a determination whether I think each of the conditions are either true or not true, and then make a determination from there. So are you requesting a full-blown?
The second one.
Second one. All right. So you're not requesting a full-blown motion to enter adjudication of guilt and revoke community supervision. And realistically, the only difference between those two is we try to call the original probation officer on the full-blown one. Otherwise, Ms. Gross just reads from her documents on whatever that officer is going to testify to anyway. So, all right. All good. So is Mr. Garcia going to enter a plea of true with an explanation to any of these conditions at this time?
He's going to say true to the skip test, and a lot of them he tried to blow into it as soon as he could afterwards.
Well, hang on just a second, Ross. Let me go down the line here. Let's start with And there are 3 condition 2s alleged. So I'm going to call them for purposes of the record. Condition 2A, 2B, and 2C. 2A allegedly was an alcoholic beverage positive or consumption of alcohol on February 20th, 2022. 2B is the same alleged consumption of alcohol on 25 March 2022. And 2C is alleged consumption of alcohol on April 2nd, 2022. Now he's going to plead not true with an explanation to those 3. Is that my understanding?
Yes, we're saying not true because of how low it actually was.
All right. Well, we'll let you get into that in argument here in a minute.
Okay.
And I've got 1, 2, 3 condition 14. So for purposes of the record, we'll call them condition 14A, 14B, and 14C. And that's where it talks about the actual level of the alleged alcohol consumption on the Smart Start mobile device. 14A says 20 February 2022. The positive, which was also alleged in condition 2, we're kind of double alleging these things, was 019. So both of them say consumed alcohol. The 14A just says they came up with 0.019, which I agree with the defense is what we call a warning bracket. Anything over 0.02 is what we call a confirmed positive. And then condition 14B, once again, a 0.019, and that coincides with condition 2B, which is dated March 25th. And then there's a violated condition 14, which I'll call 14C, which alleges a violation with alcohol consumption that blew a 0.030 on the Smart Start mobile device, which would be considered a positive by CSCD standards, in my understanding. Then there's a condition 16 that talks that he has not completed the new intervention program, which I guess is the catch-and-hit program, which is our outpatient drug program, although we all understand he has time left to do that. Will that be accurate?
Yes, sir. I think he has almost a year left on that. So.
All right. So he's going to plead true with an explanation to 16, I assume.
Which one was that?
16 is the one where he hadn't finished the catch-and-hit program.
Yes, but I think he still has quite some time to do that.
No, I agree. I'm just trying to determine whether he's going to plead true or not true. I don't care how he pleads. Just let me know how you want to plead.
I guess true that he hasn't completed it yet.
All right. How about not true with an explanation to all of them except for number 16, and true with an explanation to 16, and that's one where he has not finished the catch-and-hit program, but of course we understand he has time to do that.
Yes, sir.
All right. All good. Ms. Gross, would you please advise the court and the parties of the status of Mr. Garcia's probation? And I remind you, you're still under oath.
Yes, sir. Good morning. Mr. Garcia has been reporting as directed. We last saw him on May 2nd, 2022. He has paid $1,581 towards his fees. He has a balance of $108, and he is currently delinquent $346. He has completed all 48 hours of his community service, as well as the DWI education and victim impact panel. However, we have no proof of completion of the CATSNP program. He has had 5 negative drug tests. He is currently on Smart Start Mobile, where he is testing 4 times per day. To date, he's had 6 skip tests. He's had 1 high BRAC and 2 warning BRACs. The high BRAC occurred on April 22nd, 2022 and registered at 0.030. Then on March 25th and February 20th, both days, he had warning BRACs of 0.19, which is 0.01 below the consideration of a positive test. And he did not blow to clear on either one of those. He has no criminal history, and his officer is requesting that the court increase his Smart Start Mobile to 6 times per day, and that you add the CATS intensive outpatient program.
In reviewing some of this information, I have a question. It looks to me like, was there a hearing on February 22nd, 2022 on Mr. Garcia?
I'm looking, Judge.
So all these 3 alleged alcohol violations are all in February, March, April 2022.
Right, and this is actually his first MTR hearing. He prior to this. I'm not showing that he's had any violation reports, so this would be the first notification of the court of any wrongdoing or lack of compliance.
I got it. Mr. Brendel, what are you requesting?
You know, that breathalyzer, they have to be calibrated, and I've had clients where we traded them out and all of a sudden everything went good and there wasn't any 0.01 or 0.02 or anything like that, because breathalyzers are not completely accurate. They have a margin of error, and we're just requesting that he trade out his breathalyzer, and then he said he's fine with using it again, and if you increase the blows on it, that's fine. But I think at this point, I don't think there's any indication he needs to enter any more programs except to finish his cat snip class, which of course he has like a year to do it. So my recommendation is just keep him on his deferred and, you know, just let him trade out his breathalyzer and increase the blows on it and then see what happens.
State recommendation.
Your Honor, the state recommends SCRAM as well as substantial compliance within 10 days.
State's getting tough.
Scram's actually, my clients like the Scram. It's just so expensive.
Right. This is the justification from the probation department. Mr. Garcia's ongoing criminal thinking errors and behavior patterns have resulted in ongoing alcohol consumption. Is that true, Mr. Garcia? Are you having ongoing criminal thinking errors and behavioral patterns?
No, sir.
That was a joke, sir. Are you gonna quit? Are you gonna not drink anymore, sir?
Yes, sir.
Excellent answer. I got it. Anything
Don't
further?
even stand by anybody drinking because it might come up as 0.01.
I'm sorry. Say again, Ross.
I said, I only think you should stand next to anyone drinking anything because it might come up as 0.01. But we just need to get that thing traded out because I can tell you that solved a lot of problems with some of our clients.
You're welcome to call the what is our lady's name that runs Smart Start Mobile?
Dottie,
McDonald, right? And we probably got a number on her, Ross, if you ever want to chat with them personally as the attorney for your client. And talk to
I've
them.
actually called Smart Start Mobile and they actually, I was able to talk to somebody and they said, we've made an appointment, come trade it out on this day. So it's actually easy.
I assure you, Dottie will not tell you that. Dottie will talk to you.
yeah, and you don't have to have the court's permission to switch a device if you feel that it's defective.
Oh yeah, I've done, you know, I've switched it with some of our clients where I felt like where it would say 0.01 and I was like, I don't know, because they need to be calibrated when they're traded in and we don't know, maybe sometimes they just don't clean them or I don't know, but 0.01 is really, from my understanding, is margin of error on those things.
All right, Mr. Garcia on clause 667-828. The court accepts your plea of true to condition 16 with an explanation, not true to the remaining condition with an explanation. I deny the state's motion to revoke your deferred adjudication or to continue on deferred adjudication with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, sir?
No, sir.
Another good answer. Good coaching there, counsel. Altering amending conditions, modifying your Smart Start mobile device from 4 blows a day to 6 blows a day immediately. That being done, if you show us a clean 30-day period of time without missing any blows at 6 blows a day and no high brax for alcohol, I'll crank you back down to 4 blows a day. But I won't know you've done that. Once you've done that, you got to let your attorney know. He'll let me know. I'll confirm with probation and we'll get that done over the phone. I'm also adding weekly UAs. Show me 4 clean weekly UAs and I'll turn you back to regular monthly random UAs. But once again, I won't know you've done that. Got to let your lawyer know. He'll let me know. I'll confirm with probation. I'm also ordering substantial compliance within 10 days, which I guess is primarily directed at CatSnip. Any programs or things you have not done, you got 10 days to catch up. You're behind on monies. You got 10 days to catch up. You need to sign up for CatSnip. Even if you don't start within 10 days, at least you're signed up and you'll know when you're going to start. Okay, sir?
Yes, sir.
Susan, what I miss?
Nothing. I just need to give him some instructions when you're finished.
That's all I got. Go ahead, Sue.
All right, Mr. Garcia, later this afternoon, you will be receiving an email from me via Adobe Sign. It'll be your alternate amended conditions. You need to sign them immediately and return them to me, okay? I
Yes,
will
ma'am.
notify Mr. Fonseca. He will be increasing your Smart Start testing times to 6 times per day. And so you may want to call him this afternoon if you have not heard from him to see what your new blow times are. He's also going to be setting you up on calling in on the telephone to do your drug testing. It'll tell you what days you have to go and provide your sample. And he'll give you the instructions for that. Do you have any questions?
About the, no, ma'am, I don't.
Okay, all
I'll
right.
talk to you. I'll review everything with him, but basically he wants you to pay everything that's past due within 10 days. We need to switch out your breathalyzer and you're gonna have to increase how many times you use it a day.
Sounds
And
good.
then the weekly days.
Yes,
for a
sir.
while. Thank you.
Okay, thanks, guys. Y'all are dismissed.
Thank you.
Who else are we ready on, Pat?
You're under Mr. Herbst is in a breakout room with Arthur. Arthur came in. Mr. Maurer sent me a text, Your Honor, which I sent you. He's asking for a reset or a bond that he's not going to be able to make it. I explained to him that next week we were not having MTR hearing.
Isn't he the one that asked for this hearing?
Huh?
Isn't he the one that asked for this hearing?
Well, I sent the judge a copy of what he wrote me on his text.
Let me text Robert directly.
Yes, Your Honor.
Did they not sign their documents yet?
Yes, Your Honor, they did.
So is anybody else ready at this time?
Who, Your Honor?
Any other?
Not at
cases
this
ready?
time. The other thing is I did text Mary Petrovich. She is sending an associate. She's stuck in the 144th. So as soon as the associate comes in, she's signing the paperwork and they will be coming, Your Honor. So we're just waiting for Mr. Herbst. He's talking with Arthur right now. Mr. Tovar, I cannot see you. We need to see you. There you go. Thank you. I appreciate that. Your Honor, I'm going to